law? Hands up, have you heard of the rule of law? Okay, I thought that would be the response. Good to check. Hands up, how many of you think the rule of law is generally a good thing? Generally, okay. How many of you, if I picked on you like a cruel academic, how many of you could happily articulate a full definition of the rule of law to the room? Anyone want to? No? And final question, how many of you think the rule of law includes a requirement on the government to keep to its international law obligations? Hands up. I noted where the civil servants were earlier. There ends the audience participation. Isn't that interesting? We have this thing, this concept, this idea, this ideal of the rule of law, and it's something that one's terribly familiar. We hear about it all the time. It's part of our language of democracy. And yet it's also something we disagree about a lot, and something that we struggle perhaps to articulate. So today's conversations, this session and the following two, about the rule of law in relation to lawyers are incredibly timely. Lawyers are under attack from multiple quarters for being professional enablers of corruption, for being legal aid fat cats, for supporting backsliding in democracy, for being woke and lefty, for not challenging or even being actively involved in miscarriages of justice. The list goes on and on. In the midst of those attacks, what does or can the rule of law offer? How can it help the profession reflect and respond? Now, being an academic and a lawyer, these questions are also important because of the law. The Legal Services Act has an obligation. It requires the Legal Services Board and the frontline regulators to support the rule of law. But how do they do that? How does that land? How does that translate? So what is the rule of law? Well, as I said, it's deeply contested, and you might expect me to offer some kind of definition, but I'm not going to do that. And I'm not for two reasons, even though you may be disappointed. The first is that we won't come to consensus in this room amongst academics, between judges, even within government. It's just not going to happen. The other reason for not getting into the debate is because most of the issues that Richard and I are interested in terms of problematic lawyer conduct, problematic lawyer ethics, fall squarely within a very basic definition of the rule of law, within the most foundational ideas of the rule of law, issues of basic legality, the administration of justice, and Richard will come on to those in a moment. So why do we have lawyers? Insert jokes. One answer is that lawyers are products of societies that have law. So where you have law that is complex, you need people to help you understand it. Where you have law, you have disputes and disagreements, and you need people to help with that as well. Lawyers act as products, as living agents of the rule of law, using their expertise and their professional commitment to stand between their clients and the state. And we sometimes forget that really important social role. Lady Hale said it like this in Three Rivers: "It is in the interests of the whole community that lawyers give their clients sound advice, accurate as to the law and sensible as to their conduct." The lawyer's job is to advise as independently and objectively as possible, and in so doing, give their clients great advice, and they also discharge their officers' respect for the rule of law. They counsel clients towards as objective and as independent a view of legality as possible. So Richard and I did some work for the LSB. I assume you've all read our 62-page report. And in that report, we said there are 7 ways or 7 elements of a legal professional commitment to uphold the rule of law. And the 7 are on screen, and Richard will give you some concrete examples in a moment of how these translate. But the key takeaway, to repeat something I've already said, is that lawyers are important social actors with important functions, functions that are critical to democracy and the operationalization of a system of justice.
Thank you, Stephen. So we've been very strongly encouraged to cut things as short as we possibly can. So what I'm going to do is very briefly talk a little bit about the second bit of that fabulous 62-page report that Stephen mentioned, how legal work done poorly or done unethically, and there's often a mixture of poorly and unethically, can impact on the rule of law and can be profoundly important to society. The law says it's not simply a question of my client's rights, Uber Alice. Lawyers owe a duty, Lord Hoffman described it in the context of litigation, a divided loyalty to both the law, to society, and to their clients. And as the courts acknowledged here in the Lumsden case, there is a values component to the rule of law, independence, standards, and what we would talk about in terms of integrity. And that's not a thick or political or contested notion of the rule of law, we don't think. We see that as something quite basic, honouring truth, respect and facts, respecting the rules and all those affected by legal decisions. As I'll come to show you, the one thing I will talk in a little bit of detail about, the post office scandal, we see repeated multi-level violations of law's values in those terms. Skip through this. I could talk to you about the issues around taking on clients, essentially the difference between the right of access to justice and the risks of enabling breaches of law, violations of law. I could talk to you about, and I will a little bit later on, about the rule of law considerations raised by inappropriate aggression and handling of disputes. And I do want to just say a little bit about non-contentious work, transactional work, work which doesn't involve fights in court or in the shadow of the court or of arbitration. If I was going to boil down Stephen and I's work over, say, the last 10 words to 2 points, it's kind of scary that I can boil it down to 2 points. Anyway, lawyers and transactional lawyers in particular, we might say, tend towards a minimalistic or apathetic attitude to ethics, we find when we talk to lawyers. Not always, but often enough for it to be a concern for us. And the one factor that seems to most strongly influence ethical inclination of lawyers, we did this with in-house lawyers in particular, but it probably applies more generally, is the attitude to uncertainty. If the facts are uncertain or the law is uncertain, how do the lawyers take advantage of that? Do they take advantage of that for their clients, and how do they do that? We think that's probably the strongest indicator. So if you like, apathy and exploitation, and I would add ignorance of not just professional rules, but basic sometimes rules of the types of legal case they're dealing with, are a prime cause, a root cause of ethical problems. And if you want one example, I'd encourage you to either go and watch Warwick Tatford in the inquiry or read my Substack on Warwick Tatford. Warwick Tatford was a barrister, is a barrister in independent practice who prosecuted cases for a case at least for the Post Office. And what's interesting about Warwick's case is he goes to the inquiry, he's read all the papers to remind himself of what he did in that case, and he apologizes for what he's done. Okay, he very decently, much more decently than pretty much any of the other lawyers involved, gives what looks like a fulsome apology for what he's done, and then he's taken through what he did by the counsel to the inquiry, and he is schooled in what he failed to do. And he has to then make another apology, and he says, you know, I didn't actually realize how bad it was, what I hadn't done, what I didn't know. And the inquiry counsel is not taking him through obscure elements of law. He's taking him through basic ethical obligations, basic bits of criminal justice procedure. Okay, it's had to be schooled in that. Okay, that leads me to my last slide. If we talk about, here are some of the things that have gone wrong, I think, in the Post Office scandal. Not all of them, but some of them. They involve, in summary, putting the client's interests first before the interests of justice, before integrity, before independence, and sometimes, I'm sorry to say, before honesty. Using the law and confidentiality in particular as a tool to take advantage of relatively powerless individuals in their thousands. You're going to hear from one of them in a minute. They sometimes manipulated facts and their legal presentation to mislead the press, the courts, and Parliament. That behaviour took place over 20 years. Lawyers in-house and in independent practice, in private practice, junior and sometimes very, very senior lawyers involved. Lawyers of all types, sometimes ignorant, sometimes too clever by half. behavior, as we may hear in a second, that have ruined, genuinely ruined lives, and was, I would argue, and we can see from some of the evidence emerging, almost certainly professionally improper. Sometimes, though, interestingly for the regulators, the behavior is very worrying, but is probably within the professional rules as drawn, and that poses a really interesting, important challenge to the regulators. I would say en masse, that behavior. The other thing to know about the post office scandal is the behavior, although the consequences are extreme, the behaviors and the examples are not that unusual. I've written about many cases of similar kinds over the years. The lawyers breached the rule of law, and I would argue, the values that underpin it, but it also reveal, I believe, the weaknesses in the profession's rules and the ways in which the regulators organise for them. That's where I'm going to end.
Richard, Stephen, thank you very much for that. Yes.